So, Chapter 3, Form of Contracts. Article 1356. Contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form, in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requires is absolute and indispensable. So, contracts are binding upon the contracting parties in whatever form they may have been entered into as long as all the essential requisites for their validity are present. However, when can we consider form as essential requisites of a contract? So the form of a contract essential. So when the law requires that a contract be in certain form for its validity. Then when the law requires that a contract be in certain form for its enforceability. So in Article 1356, there are two forms of contract. There are contracts in writing, and the second is contract in a public instrument. So contracts with must be in writing to be valid. So donation of personal property exceeds 5,000. And agent authority in sale of land or any interest. Or contract of anti-crisis and stipulation to pay interest on loans. In contract with must be in a public instrument to be valid, a donation of real property and sale of real property, and included partnership where real property or rights is contributed, such as or when capital contribution exceeds 3,000. So, in clarification of contracts according to form, included a inform or common or simple contract, or that which may be interest entered into whatever form provided all the essential requisites. And second, formal or solemn contract. So, solemn contract, or that which is required by law for its efficacy to be in certain specified form. Then, in form of a contracts, we have rule regarding form of contracts. So first, we have general rule. So contracts are binding and therefore enforceable, like what I said in intro. So we have an example. So plaintiff comments an action against the defendant to recover as owners a certain parcel of land located in the pueblo of Molo province in Iloilo. So lower court found that the plaintiff were the owners and were entitled to the possession of all the parcel of land described in said paragraph. So the complaint except the parcel together with the tile roof house located. So the issue is, can defendant to prove by means of oral evidence the owner of the said realty. So an oral contract of the sale of real estate made prior the enactment of the Code of Civil Procedure is binding between the parties there, although it may still be necessary for the parties seeking to enforce such contract to take some action to secure the execution of proper documents. But this requirement will not render the agreement invalid. And so the Article 1357, if the law requires a document or other special form as in the acts and contract enumerated in the following article, the contracting parties may compel each other to observe that form. Once the contract has been perfect, this may be exercised simultaneously with the action upon the contract. So, this article grants the contracting party the power to compel the other to execute the formalities required by law. An irregularity in the formalities may affect its enforceability. It has been held that where a document purporting to be mortgaged on a all real property mortgator contains no detailed description of the land mortgage, and therefore it cannot be recorded and thus made effective.